Good morning, everyone. Thank you for joining us today for the HEARTH Act overview for tribes. This is our fourth of 5 tribal outreaches that the National HEARTH Act team does every year. Everyone in this call was sent a copy of the agenda. So as you can see, our acting division chief is not with us today, but we will go ahead and just begin. The speakers today include myself. I am Sharon Kidman. I am the National HEARTH Act coordinator for the Office of Trust Services, Bureau of Indian Affairs at Central Office. We also have Suzanne Nunn from the Office of the Solicitor, Central Office, Washington, D.C. And for a special announcement today, we have Dr. Erin Painter from the Director of Education from Kaufman and Associates Incorporated. So that will be at the end of the presentation today. So just so we're clear and everybody knows where they're at, where this today is a presentation for regarding the HEARTH Act policy, as well as the tribal checklist for HEARTH Act regulations that we will be going over. Your cameras and your cameras and your mics are turned off. For today's session, we ask that everybody, if you have a question, go ahead and put it in the chat. We will address the questions at the end of our session before we turn it over to Dr. Painter. And then the same will apply. We will let Dr. Painter do his presentation, and then we will take any questions you may have for him after he has done his presentation. But as far as that's concerned, that is it. Everybody has the agenda, so we're gonna go ahead and hop into the policy. So like I said, everybody was given a copy of this policy yesterday. If you don't have it, you can go to the Office of Trust Services HEARTH Act website and pull it down. So if you lose it, don't worry about it. The website always has a copy of it on there, along with the tribal checklist. Today, this session is also just to kind of give tribes an inside look of if they are interested in drafting and approving their own HEARTH Act regulations for secretarial review and approval. This is how you begin. So today's discussion is about that process of how do we begin, what do we need to do for that part of it. So this is where we will discuss the steps that you need to take to do that. Steps like regarding 638 contracts, we don't discuss any of that. That's not our arena. Also, anything regarding TAMS access, we don't discuss that. That's not, again, our arena. Today, we're just simply addressing the beginning steps of what the tribe does or should do or can do before they submit a HEARTH Act leasing ordinance for review, secretarial review. So today, on the policy before you on the webpage, I'm going to go ahead and scroll down because a lot of this is stuff that you can read yourself if you haven't already done so. This policy was first implemented in 2020, but was amended last year in June of 2022. We have the responsibilities, the offices, some definitions, and then down on page 5 is where we begin with the process of approving and denying tribal leasing regulations. Now, as tribes are well aware, and maybe some people on this phone call are not, but HEARTH Act includes tribal regulations. A tribe can draft regulations for agricultural, business, residential, wind and solar, public, religious, educational, recreational. It covers a lot of things, which when the solicitor does their piece, they will go more into that, but it covers those. We've had tribes submit separate codes, one for leasing, one for ag, one for business, one for wind and solar, or we've had other tribes do what we call a comprehensive code, which includes all those disciplines listed under the HEARTH Act. So today, the submission process, is laid out for you. It begins on page 5. 1.7A for submission. The tribe must submit a complete HEARTH Act regulations package to the BIA Office of Trust Services, Division of Real Estate Services. And then in letter A right there, it goes into detail about what is needed. Number 1, we need an original cover letter that includes a request for review and approval of the regulations under the HEARTH Act. The contact information for parties with decision-making authority regarding the regulation, for example, tribal officers, legal counsel. And number 3, any special circumstances regarding submission of the regulations, an urgent need for approval, a unique provision included in the regulations, etc. Also, we ask that the letter come from the tribal leader, as this is a government-to-government relationship. We understand that in that letter, they will appoint who is to be their HEARTH Act POC. So while we may work with attorneys, we expect the direction to come from the tribal leader themselves. So just FYI on that. Letter B, we need one original, in addition to the cover letter, we need one original of the regulations approved by the tribe and signed by the authorized tribal parties, and a tribal resolution authorizing the regulation, and it must be an original and not a copy. If the tribe submits a copy or the submission is incomplete, it will be considered as unofficial and not be reviewed or forwarded for decision until an original, fully executed regulation and tribal resolution is received. And I will tell you that for the most part, we have never received an incomplete one. I think tribes, they understand, they know. So that's just put in there for in the event that we did receive something incomplete. So the address in this particular one is not the correct address. We will give the correct address in the chat. It says 1001 Indian School Road. That is not the correct address. So we will give you the correct mailing address in the chat to this webinar today. What is the next step after you submit it? Well, concurrently, I will request the tribe to email a PDF and Word version of the submission to me. So that term right there that you see, HACK, this one, that is my title. HEARTH Act Coordinator is what it stands for, otherwise known as the HACK. So the policy only mentions the HACK. It doesn't mention me by my first name because I could leave this job and there's going to be another HACK. So it's just the HEARTH Act Coordinator. So at this point, that would be me. So concurrently, the tribe will email me a PDF version of what they mailed, along with the Word version of the regulations, so that we can begin our review. And on number 2, just to point out here, it does say the initial submission should not be emailed, mailed, or hand delivered to the Bureau's regional or agency office. So we ask that the tribes not submit that to the region or the agency at all, because all submissions must come to central office, Washington, D.C. Going down. Now, this is where I won't read these verbatim because you can take that time to do that yourself and take a look at it. But really what goes on after we receive it is that it's received, it's date stamped, and that stamped is when we know that's our go-to. That is our beginning point, is the 120-day statutory time frame begins once that package is received by our office. And we use that date because we log into our own, we log that date in and we go 120 days from that, because at the same time, I will also issue an acknowledgement letter during this time to the tribal leader. And in that acknowledgement letter, I will give the 120-day time frame. The end date is put in that letter. So the tribal leader knows from the get-go that here is the time frame we have to work on this. And we hope that we can get them secretarial approval by that time. Um, the next steps just go into greater detail about how we review what I do with it. I put it in the log. And then after that, what I do is I concurrently send an email to the BIA region, the region that has jurisdiction over that tribe. They are included in the internal central office review. So the region and the central office solicitors and our team, DRES, well, that would include only me because I'm the HEARTH Act coordinator. So the three parties are included in the internal review. So we have 30 days from the get-go, from the time that we receive it. We have 30 days to do what's called an internal review. So we do our own comments individually. They will send them to me. I will put an end date on that. I will say I need these by the close of business on, March 10th. And almost all of the regions, I shouldn't say almost, all the regions are very good, and they meet that time frame along with the solicitors. The solicitors are included in that. So everybody must adhere to the time frame. And so we're not sitting there going, oh my goodness, we're 15 days late. No, there's none of that going on. So after the 30 days is up, we get an additional 15 days. And I'm going to scroll down. We get an initial 15 days right here, number 4, to schedule an internal call. And we will have a joint discussion and talk about the comments that we have made as an internal team for BIA, the three parties. Once that call has completed, and it's generally the same day, I make it a rule of my own that I will notify the tribe the same day they will receive a copy of those comments that we have done. And they are sent to only the POC listed on the letter that the tribal leader has indicated. We do not allow additions to the meetings unless the tribal leader indicates otherwise. So please bear that in mind, that in the cover, that it's very important that the cover letters are specific. So if you want John and Jane Doe, but you didn't put Emily on there, and now 45 days later you want Emily, the tribal leader, since it wasn't in the cover letter, is going to have to email me saying, please add Emily to the call. So just bear that in mind. So after that, we send them, and then we schedule what's called the external call here in step 5. We have 10 days to set that up, and I know tribes are very busy, so it's very important that we get the call set up and done within that 10-day time period, because again, remember, there's the whole picture we're looking at is the 120 days. We don't really want to sit on these packages at all. So as quick as the tribe responds to us, we will respond back, and that way we keep the time frame moving. So we have the external call with the tribe. The tribe, this is their time to ask us questions about the comments that were made, and this is where we have that working session with them with the document. So I make notes during that call. I send that document back to the tribe when we are done with the call, and then the tribe will then have it in their hands, and they will work on it for modifications, and then they will return it to me as soon as they are done with those modifications. And like I said, bearing in mind that it depends on how fast the tribe is moving on this. The time frame is 120, but the tribe may have emergencies or whatever they're dealing with. We don't know that. They would have to tell us that, so we know that they might need maybe a 30-day extension on that. So we have had that happen, and that is fine. You just need to let me know that if you need an extra 30-day extension to complete your modifications. Scroll down because we've kind of covered that number 5 point. So at the end of that, then let's say the tribe returned their red line. When I give back the modifications in an email form, I give very explicit instructions. They do say, please, here are the comments. Please return your red line modification to me with the BIA comments intact. So we always tell tribes, don't resolve the comments, don't delete them. We want to see them in there so that we know that you in fact fixed that one item that we had questions on. So those are the things that I will stipulate in the email. So the directions are always very clear in terms of what it is we expect back from the tribe. Letter C down here talks about modified submission of leasing regulations. I won't read these verbatim because you can do that yourself. These are very easy to read. It's just a step-by-step process, but I usually receive them, and when I get them, I look at them, and I also pass them on to the solicitor, and we are looking at these so that we can see whether or not those items were indeed corrected or modified as per the meeting discussion. So that letter C just kind of goes into what we do during that time and the actual step-by-step that we take. Letter D, it talks about failure to resubmit modified leasing regulations. We've had this happen once or twice, and really what we do is just simply work with the tribe. There are times that a tribe will change their mind right in the middle of the process, and that is perfectly okay. They may decide, oh, you know what, we're not ready for this yet. Maybe they don't have things set up, the contracts or whatever it is they need to do. And they say, well, we're going to go ahead and table this for now. So we will simply just withdraw their application, and they will reapply at a later date if they so choose. So it's not a bad thing if there's a failure to resubmit. This is just a step-by-step of what happens during that process. And I just quickly looked and seen a question about, can we get a copy? Yes, you guys received copies of what I'm presenting yesterday, or you should have. If you didn't, I can resend them after the meeting today. So, but this document that I'm going over is the actual policy, the HEARTH Act policy. So everything in this document was provided to the participants today. So there's the failure to resubmit process. And then the one that we all want to reach, and that includes us at the BIA, is the final submission. The final submission is when the tribe when we have reached an agreed upon version of that document, you will receive an email from me, and I will say those words in that email. It will say, hello, so-and-so, here is the department has completed our review. Here is the agreed upon attached final leasing ordinance. And then I give instructions in that email saying I will send a second email to the tribal leader. Real quick, if some of you can't see my screen, I'm not sure what to tell you about that. I can say that you might want to stop, leave the meeting and then join again and then try, because I'm not sure what to tell you about that. I think it's each individual user's capabilities of what their internet is doing at the time. So if you're having a bad storm, it might interfere with that, but just know that that you can leave the meeting and come back and see if it'll pop up for you again. But during the final submission, the tribe will do similar steps as they did during the initial submission, which is number one, to submit a cover letter. They will submit the original modified residential leasing ordinance, as I'm just using residential as an example, the residential leasing ordinance, and the tribal resolution authorizing that leasing ordinance. So they'll do that when we reach the final. So they'll mail those in, and they will concurrently email me the PDF version. Again, this time they will not need a Word document. When it's the final, we no longer need a Word document. We just need the hard copies, and they can PDF email me the hard copies. And we always like to tell them to do it once they've mailed it, to email us at the same time, letting us know that they mailed it, but that here is a PDF version of what we mailed you. And then Once I receive those, so E here, final submission and approval, they kind of go together. Once I receive it, excuse me, on my end, I am notified immediately when the package arrives. So I go in and I pull it down and I start creating the documents that we will need, and they're listed here in number 1 under approval. Right here. I will start working on those documents that I'm going to need to submit into what's called the data tracking system, DTS, on our side. And that's where secretarial approval occurs, is within that system, because once it leaves our hands, meaning the Division of Real Estate Services, once it leaves our hands and it goes through that system, there are other offices that will be reviewing this. And one of them is RACA. The other one are Asia's counselors, Department of Economic Development. They will review it. So there are other offices that will review it once it's inside the system. So they too have a time frame as to when they can, as to how long. So the end product being that once it's been cleared by the regulatory commission committee, sorry, they will RACA, Regulatory Affairs, Office of Regulatory Affairs and Collaborative Action, they will publish and post the federal notice for the tribe. And I receive a copy of that document. And then when it's all done and the assistant secretary has signed, then I have those documents. And then the last thing I do is I submit a letter to the director of Bureau of Indian Affairs, who he or she or their acting will sign the letter. And then once I have that letter, I will notify the tribe, giving them a copy of their approved tribal regulations with a copy of the approval page that Mr. Newland has signed, and the Federal Register notice and the cover letter signed by the Deputy Bureau Director. So they will receive all of that at the end when the process has completed. So the steps that we have gone through begins from pages 5 through 9. So if you guys want to take a look at that, the tribes on this call today, you can do that. And we can put your questions in that chat because we will get to them. But for now, that is the end of what I wanted to go through today with the tribes that are present and on this call, and about what you need to do, what happens when you do it, who gets to be a part of it, and what to anticipate. Okay. And again, that's it begins on page 5 with initial submission through page 9. Those are really the steps of action that are taken during this whole process. So those will be important pages for you if you're interested in that. But as far as the mailing address, I will put that in at the end of this call. I'll put it in there so you guys know the correct mailing address. But that's it for me on this part. I'm going to now go ahead and turn it over to Suzanne Nunn from the Office of the Solicitor, Central Office. Suzanne?
Yes. Hello, everybody. My name is Suzanne. I've been doing HEARTH Act since about 2019. Prior to that, I worked for the National Indian Gaming Commission for 3 years. And then prior to that, I had about 7 years in tribal governments working in Arizona with my family's tribe, the Salt River Pima Maricopa Indian Community and the Gila River Indian Community, as well as Fort McDowell and Crit. And that's about it. That's just for my experience. Also joining me today is David Moran. He's a solicitor as well. David, would you like to introduce yourself?
Yeah, good morning, everybody. Thank you for joining us. Yes, I've been with Solicitor's Office since 1991. Been here. I've done mostly work in land, minerals, and environmental issues. I have been working on the HEARTH Act since basically the statute was passed and implemented by the department. And basically, both of Suzanne enjoy our work, and both of us believe that it's one of the most successful, Indian programs that Congress has initiated over the years. And I think it basically contributes, of course, to tribal sovereignty and economic development on tribal lands. Thank you.
Thank you, David. So we're going to just start with when David and I do our legal sufficiency review. Thank you, Sharon, for putting this up. We've created a checklist because the Tribal HEARTH Act leasing regulations have to be consistent with the 25 CFR 162 leasing regulations. We've created a checklist for us to go through for our legal sufficiency review. We understand and appreciate the uniqueness of each tribe and each culture and each community, and we work really hard to try and incorporate the different aspects of the various communities that we work with. So the provisions that are listed on our tribal legal sufficiency checklist, as well as the definitions, everything on this checklist, they do not need to be verbatim. So we don't look for a word for word verbatim definition of agricultural land or assignment or whatever it is. We look to make sure that each one of these provisions and definitions are consistent with the 162 regulations. So this sample checklist is available on the HEARTH Act website. If anybody would like a copy of it, if you're in the process of, or if you're thinking about looking at creating your own tribal HEARTH Act regulations, this checklist is available to everybody and anybody who'd like to see it. If you can't find it on the website, please contact either David or myself, and we're more than happy to email a copy to you so that you have it. The checklist will give you the definition or the provision that is either required, so it's mandatory to be in the tribal regulations, or is what we would strongly recommend. So back up just a tad. When we do our legal sufficiency reviews, we put our comments into three categories, basically three categories. The first category is required. So if you get a comment that says required, that means that whatever we're saying in that comment must be in the Tribal HEARTH Act regulations. It's just got to be there. If there are questions, or if there's an issue that a tribal community has with a mandatory provision, David and I are happy to discuss that and work around things as much as we can, within the parameters of the HEARTH Act statute and the leasing regulations. The other comments that our categories are strongly recommended. A strongly recommended comment is something that's not mandatory. It's not required to be in a tribal HEARTH Act regulation. However, from David and our, standpoint, it will strengthen the tribe's HEARTH Act regulations. It's something that we see, okay, well, while this is not mandatory, it may be a good idea for the tribe to put this in their code, A, for either transparency purposes, or B, just to strengthen, to give their tribes a more solid foundation in their HEARTH Act regulations. An example of a strongly recommended definition would be the best interest of the tribe. The best interest of the tribe definition is not required. However, David and I have found throughout the years that if a tribe includes a best interest of the tribe definition in their Tribal Hearth Act regulations, it provides the tribe with more flexibility to determine, to make a determination, to make a leasing decision or a leasing determination. For example, one of the places that we really look at it, we try to explain to the tribes is rental compensation. If a tribe, for example, is creating a housing project and they're drafting Tribal Hearth Act regulations for residential leases, the tribe may want to consider putting a best interest of the tribe definition in their regulations, because that allows the tribe to offer these tribal housing units for less than fair market value or less than rental annual value or less compensation. If the tribe would like to do a low income housing unit, you can do that in the best interest of the tribe. The tribe can say, hey, this is, we've discussed it and we've determined it's in our best interest for our community that we're going to offer these units at less than rental annual value. And so the best interest of the tribe definition is, again, not mandatory to have in a Tribal Hearth Act regulation, but it is a good idea to give the tribe the flexibility to make those determinations. Another example would be performance bonds or insurance. If the tribe determines that it's in its best interest to waive a performance bond or to waive the insurance provisions, it can do that. If it has the best interest of the tribe definition in its Tribal Hearth Act regulation. Sharon, you can go down, please. The next section that we have, keep going, Sharon. The next section that we have are required leasing provisions. So the required, keep going, Sharon. There you go. Thank you. Required leasing provisions are things such as the Hearth Act, Tribal Hearth Act regulations must identify what lands the regulations apply to. Now, this is very important to note that Hearth Act only applies to 100% tribally owned land. It does not apply to individual Indian-owned lands. It doesn't apply to fractionated interests where the tribe may own 60% and individuals own 40%. It doesn't apply to mineral interests, and it does not apply to fee lands. It only applies to trust or restricted lands. So that's really important to make note right off the bat. And that has to be in a provision in the Tribes Hearth Act regulations. The Tribes Hearth Act regulations have to define what types of leases are covered by the regulations, such as residential, business, agriculture, wind and solar, wind energy evaluation, things like that. It also must include a provision that includes the tribe's authority to enact laws and be governed by them, such as a tribal constitution or tribal bylaws. Now, David and I do recognize the fact that there are tribes and pueblos that do not have constitutions, and that's okay. That's not a problem. We just need to have a provision which states that the tribe has the authority to enact this law and to administer it. And so this, I'm not going to go over each and every one of these, so I'll let you guys look at it. And if you have any questions, you can ask David or I. But I will point out one more. The tribes leasing Hearth Act regulations have to identify whether the lease can be amended, assigned, renewed, or if a leasehold mortgage can be had, and how that leasehold mortgage is is basically handled by the tribe. So you cannot, as you guys know, you can't mortgage the land, but you can mortgage the leasehold interest. And a tribe may determine it's in its best interest to not have to approve all those leasehold mortgages, or a tribe will say, yes, we definitely want to have the opportunity or the authority to approve a leasehold mortgage. So those are things that we look at also for in the legal sufficiency review. Sharon, please go down a little bit. There are basic provisions that must be in every lease, such as the names of the parties under the HEARTH Act. And because the land is always 100% tribally owned, the lessor is always the tribe. So the tribe may determine that there is an entity, a tribal, maybe I don't know, a tribal entity of some sort, a tribal arm that will handle those leases, and that's fine. But the lessor ultimately is always the tribe. The lease must, and the leasing regulations must provide for definitive term. Here you can see those terms: agriculture, business, and wind and solar are 25 years with 2 25-year options to renew. If a tribe has options to renew in their Tribal HEARTH Act regulations, they've got to provide the specifics in the time and manner the option must be exercised, or if it's automatically effective, and any additional consideration that will be due upon the exercise of the option, and any other kind of condition that the tribe would like to put on that option to renew. Residential, public, religious, educational, or recreational leases can be for a maximum of 75 years. You do not need to create a lease with with options to renew. 75 years is the max, and if you'd like to make the initial term 75 years for those types of leases, that's fine. However, you can break it up as well if you want. However, the tribe, whatever works for that community is fine, as long as it's a maximum of 75 years. A wind energy evaluation lease can only be for 3 years with 1 3-year option to renew. And that is the shortest term of these HEARTH Act leases. And the caveat to that is that if a tribe is executing a wind energy evaluation lease, which we call wheels, you can put language, you can add a provision in that lease that says that this wheel will revert to a wind solar resource lease at the end of its either a 3 years or 6 years, depending on whatever the lease term is for that specific project. So you can convert a wind energy evaluation lease into a wind and solar resource lease, which again then goes up to the 25 years with 2 25-year options to renew. Sharon, go down. These are the other required provisions. These are all the required provisions of the rental compensation. And again, I'm not going to go through each and every one. However, I will say that if a tribe determines that all of the payments, the lease payments, are going directly to the tribe must maintain documentation of those lease payments. And the documentation must be sufficient enough to enable the secretary to discharge the U.S. Trust responsibility. That's a provision in the statute itself, and that must be in the tribe's HEARTH Act regulations if that's how the tribe wants to accept the payments, the lease payments. Sharon, please go down. David, is there anything, I'm going to jump in, is there anything you want to add so far?
No, you're doing a good job. You're covering everything. Thank you.
Okay, thank you. There are required lease enforcement provisions. Of course, there can't be any illegal conduct or activity on the lease premises, and the lessee has to comply with all applicable tribal and federal laws and ordinances and other requirements. There has to be the tribal leasing regulations must identify a process for enforcing lease violations. as well as it's got to identify a process that discusses cancellation or termination of the lease. Sharon, go down, please. The tribe can identify or can state that if a tribe has a tribal court, that the tribal court, that any disputes between the lessee and the lessor can be resolved in tribal court. If you would like, that's fine. Or in the alternative, if the tribe wants to determine if it's best for the tribal community to say that final leasing decisions are not, there's no recourse for a final leasing decision. All decisions by the tribal council are final. You can put a provision in there as well. And then, there also has to be indemnity provisions, which state that the tribe and the U.S. Government are held harmless from any loss or liability by the lessee. Keep going down, Sharon. These are the required insurance provisions I was explaining that can be waived if in the best interest of the tribe. These again are the performance bond provisions, again, not required in residential leases or wind energy and wind solar leases, but in the other types of leases, they can be waived if in the best interest of the tribe. Then there's permanent improvement provisions. So say, for example, this is a business lease and the business is constructing a permanent improvement on the property, a building, for wind energy or wind solar, they're putting up, some kind of a facility equipment that goes with that lease. If there are permanent improvements allowed, that has to be noted in the tribe's HEARTH Act regulations. In addition, there are specific items that are mandatory for permanent improvements. The tribal HEARTH Act regulations must state whether the improvements that are authorized will remain on the lease premises upon expiration or termination of the lease. If they'll remain there, will they remain in a condition satisfactory to the tribe and become property of the tribe? Will the lease require those permanent improvements to be removed within a specified period of time at the lessee's expense, or will they be disposed of by other means that are specified in the lease itself? Doesn't have to be in the tribe's leasing regulations, but it does have to be in the lease itself. The regulations and the lease must also provide that if a permanent improvement is going to be remaining on the land, the tribe has the option to waive any removal requirements and take possession of those improvements. I think that's a very important provision. It's important for the tribe to be able to do what they need to do in case of, an issue. I worked for a tribe where I did business leases for a tribe, and we had a person who was a business that was not happy with having to terminate their lease, and they left all kinds of things on the land itself. And it was very important that in the lease it stated that the tribe could hold the lessee responsible for any costs to removing that those permanent improvements. So it's important for the tribe to have that in there. Sharon, if you go down, please. The next provisions will be specific to wind energy evaluation leases and wind solar resource leases. These, again, I'm not going to go into too much specifics on them, but these are all mandatory in wind energy and wind solar leases. Go down, Sharon. And then finally, the HEARTH Act, these are the environmental rate provisions. The HEARTH Act allows tribes the flexibility to authorize leases without having to go through the very stringent NEPA requirements. But in order to do that, the tribe has got to have specific environmental provisions in its tribal HEARTH Act leasing regulations. The regulations must include a process, an environmental review process that evaluates identifies any significant effects of the proposed action or the lease activity on the environment. Now that's direct and indirect. That isn't just direct effects, it's both direct and indirect effects. The tribe's HEARTH Act regulations have got to identify a process to ensure that the public and the public is not limited to just the tribal community. The public has got to encompass more than just the tribal community. And I didn't go through that with the the definition of public, but the definition of public cannot be limited and narrow to the point to where an affected party will not have the opportunity to comment on the lease activity. Now, we have worked with our environmental people and we've massaged the definition of public over the years, and we've come up with what we think is a really good definition, very workable. We understand that there are issues with tribes with, there can be, acrimonious relationships with people that surround the tribes that are non-natives. We understand all of that. And so our definition that we've come up with includes people that will be directly and substantially, not directly, but substantially affected by the lease activity. So if by the tribe having to ensure that the public is informed of and has a reasonable opportunity to comment on any significant environmental impacts, the tribe has the authority, the ability, the discretion to determine itself what it feels are relevant and substantive comments. So a tribe doesn't have to respond to every Joe Schmo that is pissed off about, whatever the tribe is doing and wants to cause a problem. The tribe only has to respond to those comments that it feels in its discretion are relevant and substantive to the lease activity or David and I really like to stress that because, again, we understand there's a lot of people that get pissed off about stuff that tribes do, and they just want to cause a problem. I did a lot of work in California, and I get it. There's a lot of special interests out there that don't like tribes. So we just want to make sure that the tribes understand that you don't need to respond to every single comment. You only need to respond to what you feel is relevant and substantive. And so, go ahead, David.
No, if I could interrupt real quick, and we can't stress that enough. I think in Congress, I think you look at the legislative history of while the act was being basically debated in committee and on the floor. I mean, there was a lot of concern that basically the tribes did not have to go through NEPA. So I think, but Congress finally decided, tribes are sovereign. I think they should decide their own environmental process. But I think there's a lot of concern as long as it's meaningful. And it's not going to be meaningful unless you get those that are going to be substantially impacted an opportunity to comment. And that's so very important. And I think as Suzanne mentioned, the definition, the sample, or recommended definition we came up with, I think addresses that issue. I think the tribe should also want to underscore the fact that You have to give an opportunity for people to comment, and you have to be responsive to those comments. That's best done by newspaper general circulation, or by, on your website. So basically, so everybody gets a chance to review the environmental survey that is done on the lease activity. But with that said, again, unlike NEPA, I think there is basically, you must respond to it. There's not really a requirement that you mitigate or substantially address those. I think you would hope that you tribe would, if the comment has some basically merit. But again, I think so. Going back to Suzanne's point, it's really in the tribe's hands. I think give an opportunity to be broad and allowing people to comment, to respond to those that you think have merit, that can be justified and substantiated and supported, and then move on. But I believe in doing that. I think tribes, excuse me, basically, you protect yourselves from, challenges in the future. I think the point that we're concerned is this HEARTH Act is meant to benefit all tribes across the country, and the lower 48 and Alaska as well. But to be sure that basically we don't have a challenge that says, hey, you guys didn't provide an opportunity to comment because we were affected. And I think basically we just want to basically be sure that the integrity of the act is upheld. Okay, that's it. Thank you.
Awesome. Thank you, David. So with that said, the only other thing that the Tribal HEARTH Act regulations have to include is a response, is how the tribe will respond to those relevant and substantive public comments that they receive. And so that's really what we look for in our legal sufficiency review. Again, we understand, David and I, we've been in Indian country for a very long time, and we understand that each tribal community has their own nuances and their own individuality and unique circumstances. And we do our very, very best to work with tribes to create and craft Tribal HEARTH Act regulations that fit the community really well. Because again, as David said, that's the purpose of the HEARTH Act. It's just and we're here to make sure that tribes can take advantage of the opportunity that is provided to them through the HEARTH Act authority, and just to have more decision-making flexibility. And so we cannot encourage it enough. The HEARTH Act is an awesome tool for tribes. And if you guys have any questions, please feel free to contact either David or I or Sharon, and we're happy to answer any questions that we can and work with you guys, with the tribal leaders and the tribal attorneys to create a really solid Tribal HEARTH Act leasing regulations. Thank you so much.
Thank you, Suzanne. So real quick, for those that are on the call, I decided also to just give you, before we get to the last portion of this, to show you what the Office of Trust Services website looks like. So I posted the link in the chat. That one takes you to the approved regulations. But when you get to the website, I'll go there right now. So there is all kinds of information on here. So if you go to, I'm going to get there. Hold on just a second. HEARTH Act, here we go. And I'll go to the approved regulations. So the link that you guys have takes you to here. And as you can see, there are they're listed from 2013 to current, and the list will keep growing. Recently, we reached the 100th HEARTH Act approval. although the Pueblo of Santa Clara didn't know that, that they were the 100th. They do now, but we reached the 100th one, and it took since the inception, so 11 years to reach that goal, and we're very proud of that, helping one tribe at a time. So these are updated. So when you click on any one of these, this is public information. I want to show you what it looks like. So for instance, we'll do Mississippi Band of Choctaw. When you click on it, it takes you right to their approved page. So earlier when you heard me say that at the end of the process, the tribe will receive a copy of their approved leasing ordinance, this is what it looks like. Each tribe will receive this page signed by the assistant secretary. And then preceding that is their law, their HEARTH Act law for that specific thing that they requested. So that's what it looks like. If ever you want to go in there, you can click on any one of these. It is all public information. But what I'd like you to do is scroll all the way down, because the links are down here. So earlier we had that question about where we want what you're showing. Well, you were emailed it, but if you didn't get that, all of this information is down at the bottom. So you click on HEARTH Act leasing down here, additional information. And if you scroll down, here are the additional resources. Here is the checklist right here that they went over. And then also the policy. So all of it is here. There are other documents in here that you are free to open up and look at in regards to HEARTH. There is an informational series that is a 508 compliant series. It's very good. This one here, you feel free to download it and take a look at it yourself. But we also have a link to 25 USC 415, leases of restricted lands. But this is the list that Suzanne just went over, BIA tribal checklist for HEARTH. It's right on there, along with the policy right above it, 52 IAM 13. So those two items that we just went over are on here. Additionally, what you also should know is that right up here in the corner where it says provided by Division of Real Estate Services, there are other disciplines in this that we cover. So other than HEARTH, if you click on it, it takes you to our main page. And here it says broadband, fee to trust, rights of way, mortgages, HEARTH leasing, leases on individual, Indian, and tribal lands. It also has a link for real estate services training. So when you click on this, another one that you might want to take a look at after today on your own time, in your convenience, is some sessions that we did last year. The same sessions we're doing now with you. 2 of them from last year were posted. We don't post every single one. We usually pick 1 or 2 from the year and we'll post it. So we still have 1 more from this year to do, which will be in October. And then we break for the holidays. We don't do any more until after the new year. Then we start again. So the 2 more will be posted here for 2023. But at the very get-go in 2023, we did a very good session with what's called the Lending Systems Focus Group. It's a bunch of national lenders are on that call. So you might want to take a look at that recorded video session. There were some great questions, and I think the tribes would be interested in hearing, that discussion. So this is all public on the website. You just have to simply, scroll down, click, and see where you're at so you can hear these training sessions. Okay. But as far as the website is concerned, that's kind of how you manipulate through it and go through and click and find certain things. That said, I'm going to go ahead now. And today we have a special presentation by Dr. Aaron Painter, and I will let him introduce himself as part of his presentation, but he has some very helpful and exciting news for Indian country. So at this point, I'm going to go ahead and turn the presentation over to Dr. Aaron Painter.
Payment, just like a land claims payment or a trust payment or HEARTH Act payment. So can you hear me?
Yes, we can hear you.
Okay, good. And so let's see, I can see the slide, our starting slide. So I'm Dr. Aaron Painter. I'm with Kaufman Associates. a retired and recovering tribal chairperson for over 14 years and in tribal government for 22 years. And so I really appreciated this presentation. I like the tone and the outreach to tribes and how to make it more direct and accessible. So thank you for that. So I'm here to talk about the READY engagement. So READY under the BIA is sponsored by the Bureau of Indian Office of Trust Services through the Indian Energy Service Center and the Division of Energy and Mineral Development. The charge of the Office of Trust Services is to protect, develop, manage, and enhance Indian trust resources for the benefit of American Indian Alaska Natives and expand economic opportunities through effective trust management that recognizes and supports tribal self-governance and self-determination. The charge of the Indian Energy Service Center is to provide the Department of Interior's Indian Trust responsibility in the energy and mineral development arena. This includes modernizing business processes to effectively develop the Indian energy and mineral estate while protecting trust assets by removing barriers to energy, renewable and conventional, and mineral development on Indian lands. The charge of the Division of Energy and Mineral Development is to provide the best possible technical and economic advice and services in assisting Indian mineral and landowners with the environmentally sound development in their energy and mineral resources. Next page, please. The BIA has been actively serving tribals in developing conventional energy since 1934 at the Indian Reorganization Act to support local tribal economies. However, while oil and gas regulations and procedures are very well defined, the same level of detail does not exist yet for renewable energy resources. The mission of READY is to analyze in depth the current limitations and barriers of renewable energy regulations on Indian lands and feedback from tribal engagement to improve the BIA's ability to serve tribes developing renewable energy. Slide 4, next slide, please. The primary outcome will be tribal engagement on the federal government's role of renewable energy development on Indian lands. Additional outcomes may include, but are not limited to, multi-agency coordination and recommended updates to regulations, policies, and procedures that improve BIA programs for proactive implementation of renewable energy on Indian land. Next page, please. So this is our roadmap. We kick-started in January through April, and we had our planning and procurement. A work group was put together with several federal agencies, and we did have a convening in a meeting in Denver. And at that meeting, it was kind of like our kickoff, and one of the first deliverables that I think is probably one of the most valuable deliverables is that Kaufman Associates, who I work for, contracted for a lit review that took this very complex issue and put it in one document. And so all of the different aspects of energy renewal, all the complexities of trust land, not trust land, interjurisdictions, all of that is embedded in this literature review document that that went out when we did the Dear Tribal Leader letter. And so Assistant Secretary Newland sent the Dear Tribal Leader letter out, and I'm going to show you a copy of the dates. But under number 2, one of the most valuable parts of this project is that it's kind of a cheat sheet or a guide for how to do development and how to get access to these resources that were made available under the Jobs and Infrastructure and Inflation Reduction Act. Okay. So then our next step is tribal engagement. That's a very critical part because we want to hear from tribal communities about the information that they need and how can they use the information that's available, how can we maximize and make that available. And then next we will be writing a report and policy recommendations and next steps. And then the next step is implementation. This is very exciting. We have dates set up for consultation later this month. We're starting out at the Hard Rock in Tulsa. So you have the information there. Tribes are welcome to register and to join whichever session they want, but we're doing in-person and hybrid. So if you are in the Oklahoma area in that region, you can come in person. Again, it's going to be at the Hard Rock in Tulsa. The next one will be at the Pachanga in California. That's August 24th. And the next is Wild Horse Resort and Casino in Pendleton, Oregon. I'm going to try to get a blanket while I'm out there. And then we do have a couple of virtual meetings only in September 6th and 7th. And then on the 11th, on September 11th, we'll be in Albuquerque. And then we are looking at scheduling one more that might be in person, but we don't have the detail on that yet, but it might be, well, I won't say any more until we get some more details. Okay, so with that, I did drop this into the chat. This is how you register. So hopefully after we're done today, you guys will get a copy. Tribal leaders will get a copy of this PowerPoint, and you can just click on that Everbright invite, and that's how you can register to attend. Also, if your tribe cannot attend, but you want the benefit of contributing your information or getting information out the other end, you can complete a form by clicking on that link, or you can send an email with your input to ready@bia.gov. And so with that, I will open for any questions, and just kind of almost like a prophetic Murphy's Law, I did drop into the chat. So if anybody wanted to cut and paste, I do have the link for how to register and how to complete the form and how to find out more information on the consultation sessions that are happening. The consultation Dear Tribal Leader letter did go out already to tribal leaders. We probably will be supplementing it when we do have potentially one more location for a consultation session. I guess the only final thing I will say is what I'm really excited about this as a former tribal leader is this is a very complex area. And, you know, some tribes may have real thriving and advanced sort of energy renewal or energy development projects in place. I think for the most part, tribes probably need some technical assistance there. So the lit search, the lit review that we did, and some of the information that's going to come about through these consultation sessions, hear what your tribal colleagues, the questions they're asking and information that they're looking for. I do think these will be a very valuable set of consultation sessions that are going to be very informative. So we really encourage people to register to attend. And that's it, if there's no questions.
Thank you very much for this information. And I'm hoping that the tribal representatives on this call will go ahead and take you up on that. If you notice in the chat, you can see that he did in fact put those links in there for you. So please go ahead and copy and paste those out of there because I don't think you will have access to the chat for too long after you leave the meeting today. So please go ahead and copy and paste that onto your desktop somewhere that you can see his information and the links that he provided. With that, everyone, we don't have any more for you today. We thank you for your attendance. The last session for HEARTH Act overview will be in October, and the link to join that one will be sent out a couple of weeks before through the regions that have jurisdictions over those tribes. So you'll be receiving contact the same way you did for this one. So we have one more for the year, and then we're going to break until after the holidays, okay? So if you want to attend again, you're welcome to do so. And if not, thank you for attending and have a great day.